Hello everyone, I'm Jeff Hampton with the Hampton Law Firm. Welcome to our YouTube channel. Today I want to talk to you about how to beat a weapons charge in Texas. By the way, if you wait around to the end of this video, I will also give you a free ebook, What to Do If You've Been Charged with a Crime in Texas. Now, one of the things that's so very important, look, there's so many people. I mean, listen, we're in Texas. You want to own a firearm, or at least a lot of people do, right? So it's almost seen as kind of one of those things of all the states in America, we have a tendency to have a pretty strong feeling about the Second Amendment, our right to bear arms. And the problem is all of that is good. I mean, you have a right. There are rights under the law, but sometimes the reality of having a right to own or possess a firearm or any other weapon for that matter, can intersect with the intricacies of the law. And even though there may be some federal implications involved in this as well, we're going to spend most of our time talking about Texas law and what to be aware of under Texas law if you are facing a weapons charge. All right, so one of the things that we're looking at here, let's do a brief overview of the possession laws of possessing a firearm or a weapon and maybe talk a little bit about a few of the defenses. So Texas law permits the open carrying of a long barrel firearm, but you must have a permit to carry. And really, we've just kind of made some changes to this. We now have some open carry laws out there that you're allowed to actually openly carry not only a long barrel firearm, but some other weapons, certain handguns that are out there, other than certain prohibited places, okay? But there are laws that restrict where and when you can possess certain weapons, particularly in certain locations. So one of the things we look at is, are there certain types of weapons that you cannot possess? This is known as possession of a prohibited weapon, all right? Now, all of these items that I'm going to give you are some examples of some that are unlawful to possess. In other words, it is against the law to exercise care, custody, or control over these types of items because they've been deemed by Texas law to be unlawful to possess. So here's some examples of that. Number one, armor-piercing ammunition. That is against the law to possess in Texas. Chemical dispensing devices, explosive weapons or devices, a firearm silencer. That's actually a federal crime as well. But if you have a silencer on a firearm, and believe it or not, even the homemade ones, I've actually seen some people charged with a prohibited weapon, possession of a prohibited weapon, because they had a homemade silencer that they created for their weapon. Then you have machine guns. It is, unless you have a license to possess this, unless you have a license to have it, general possession of a machine gun can be a problem. Also, certain types of short barrel firearms, tire deflation devices, or zip guns. Those are examples. And offenses to this law range from a Class A misdemeanor. It can go all the way from a Class A misdemeanor to a third-degree felony. Remember, a Class A misdemeanor is punishable by up to 1 year in county jail and up to a $4,000 fine. And a third-degree felony is punishable by up to 10 years in prison and up to a $10,000 fine. Okay, now what about, we've talked about prohibited weapons. What about carrying a weapon onto a prohibited place? What are some examples of prohibited places? Well, many times you cannot carry a firearm on the property of educational institutions, election polling stations, all government offices, courts for sure, racetracks, airports, or within 1,000 feet, this is kind of a weird one, within 1,000 feet of an execution site on the day of a death sentencing. But there are always exemptions, right? There are exemptions. There can be military officers, prison guards, court officers are allowed to do that. And another thing is, if it is clearly posted that it is a prohibited place, and you are able to see that you are not permitted to bring in a firearm to that location, you've been given notice that you can be charged with up to a third-degree felony for possessing that weapon in a or on a prohibited place. Now, you also have the Class A misdemeanor of unlawfully carrying a weapon, the unlawful carrying of a weapon. It is permissible to carry a handgun on your own premises or an area under your control, or in a motor vehicle or watercraft owned by you or under your control. However, you cannot, under the law, you cannot lawfully display it in plain view, be engaged in criminal activity, be prohibited from firearm possession, or be a member of a criminal gang. Now, one of the biggest ways that you find unlawful carrying of a weapon is if you have a weapon in your vehicle. This is one I'm going to use as an example. You have a weapon in your vehicle and you get pulled over and you're being charged with DWI or possession of an illegal substance. So let's say you're charged with possession of a controlled substance or possession of marijuana. Let's say you even have a concealed handgun license, right? Or, you've got the weapon in your car. Well, here's what ends up happening. You end up getting arrested for that DWI, hypothetically, if the police believe they have probable cause. Then they slap an additional charge on you of a Class A misdemeanor, which is unlawful carrying of a weapon. Because even though you might have legally had the ability to possess that firearm in your vehicle, now because there was separate illegal activity going on, allegedly, DWI or possession of a controlled substance, now the police are allowed to charge you with that because of the additional illegal activity. All right, what about unlawful carrying by a licensed holder? You cannot intentionally display a handgun in a public place unless you are carrying it on a shoulder or belt holster and the handgun came into view. Now, a lot of this has changed, okay? The old law talked about you can't just unlawfully display it or have it available for people to see. In September of 2021, that law in many ways has changed where you can now open carry. There are less limitations on your ability to openly carry. Now, I want to give you a heads up on this. Be careful, because sometimes when you open carry like that, you become a target of other people. And sometimes they decide, you know what? Ooh, look at this guy. He's openly carrying. I see he's got a gun. And any type of altercations or arguments that come about, let's say you get into an argument with someone, now all of a sudden, here's what they're going to do. A lot of times when you have a weapon in your possession and that person, there's an altercation that takes place, an exchanging of threats or frustrations or whatever's going on, that person can now call the police and say, that guy had a gun, he had it sitting on his hip, he grabbed a hold of it with his hand, and in the process of him maneuvering or manipulating that weapon, I felt in fear of serious bodily injury or death. Guess what happens? You're now charged with aggravated assault, deadly weapon by threat. Now you say, oh, that doesn't happen. That's impossible. Friend, let me tell you something. It happens all the time. So be very careful. If you're going to openly carry, if you're going to have that firearm, be aware of the fact some people, some hotheads that are out there will use that as an example to try to get you charged with up to a second-degree felony. All right, now what about unlawful possession of a firearm? Well, listen, if you have a previous felony conviction, you cannot lawfully possess a firearm, certainly within 5 years of release or from conviction or supervision. And what I mean by that is if you have a weapon for whatever reason, doesn't even matter. Let's say they only found out about you having the weapon because you defended yourself against someone else. Technically, within 5 years from your release or conviction, if you have a firearm in your possession, you can be charged with a third-degree felony, punishable by up to 10 years in prison and up to a $10,000 fine. Here's the last one we're going to talk about is unlawful transfer. You may not lawfully sell, rent, lease, loan, or give a handgun to the following groups of people. A child under 18 years old without written permission from the child's parent or guardian. You may not do so to a person who is intoxicated, a person who intends to unlawfully use that gun, a person convicted of a felony within 5 years of their release from confinement or supervision, a person known to be under an active protective order. An offense under this is a Class A misdemeanor. It can range anywhere from a Class A misdemeanor up to a state jail felony, both involving potential jail time. So what happens if you're charged with a weapons charge? What if you're facing a weapons violation? Well, according to the Texas Code of Criminal Procedure, this is what happens. The magistrate will release the weapon to the owner before the 61st day after the initial notification, as long as no prosecution or conviction occurs, provided that the owner makes a written request for the weapon to be returned. So people ask me this all the time. If something happens with one of my weapons like this, or if I'm charged with it, is there a way to get the weapon back? Yes, there is potentially a way to get the weapon back. But if the weapon is not requested to be returned, the magistrate has until the 121st day after the initial notification to have the weapon forfeited to the state for use or forensics, sold at a public auction, or destroyed. The weapon may not be returned to the owner, though, under certain conditions, including, here are some important ones, if the prior weapon offenses exist, So let's say you have prior weapon offenses. The judge can deny the request. And if the court determines that possession would pose a threat to one or more individuals. So that's one of the questions that I know I'm asked all the time. Can I get my weapon back? Those are some of the considerations to take into account. Now, finally, let's talk for a few moments about possible defenses against your weapons charge. Well, one of the things is just generally you have a Second Amendment right to bear arms. And one of the other thing is a common defense is, what if there was an illegal search or seizure? If the police did an illegal search and that led to them finding the weapon, then your attorney, your criminal defense attorney, can file what's called a motion to suppress to have the actual search deemed to be illegal. And under the Fourth Amendment standards of the United States Constitution, everything that's seized after the fact is no longer admissible in court. Okay? Then finally, let's talk about the traveling presumption that exists. Generally, back in the old days, people used to get arrested all the time for having a weapon in their car. But, the police officer pulls them over and says, "Whoa, what's this gun in your car?" Well, now there's this traveling presumption that exists. This goes along with the example I gave you before. There's a presumption that the weapon's being transported from one location to another unless there's other illegal activity that takes place. And like I mentioned before, whether it's a DWI case or a possession of controlled substance or marijuana case, many times, here's what's going to happen. If that police officer pulls someone over and they smell the odor of marijuana, burnt marijuana, or if they believe there's other criminal activity that may be going on, they're going to use that as probable cause to search the vehicle and do everything they can to mount up those charges where you could be potentially facing a gun charge, okay? So here's the point. Maybe you're facing a gun charge. We have only just generally touched the surface of the types of gun cases or gun charges, weapons charges more specifically, that you could be facing. And if you are facing a weapons charge in the North Texas area, and if you would like a free case analysis and a consultation, don't hesitate to contact the Hampton Law Firm at 817-877-5200. By the way, I promised you if you waited around till the end of this video, I would give you a free ebook, What to Do If You've Been Charged with a Crime in Texas. Click the link below, and once you click the link, input some of your email information, we'll send it right over to you. And if you enjoyed what you heard today, subscribe to our YouTube channel, like our video, and we'll be happy to send you more great content just like this. Thanks again for joining us. Have a great day.